Welcome back to Law News Network. I'm Heather Hansen, and I'm really excited about our next guest. It is Alan Tuerkheimer. He is a jury consultant, a psychologist, and an attorney, and here to talk to us about all things jury consulting, which is a fascinating topic to me. Welcome, Alan.
Hi, nice to be here. Thanks for having me.
Thank you for being here with us. I know that this is something, all I know about jury consultants is what I've seen on TV. There's that new show, I think it's called Bull or something.
Yes.
And Dr. Phil, of course, I know that he started off as a jury consultant. Tell us a little bit, just in general, about what it is that you do for lawyers, and then I want to get specific about the Valerio case.
Sure, I'd be happy to. So, not surprisingly, it's a little different than what you see on TV and what's been in movies and portrayed in the media. But as a jury consultant, I help attorneys communicate to juries. That's essentially what it is. I help with communication and helping them craft a message that resonates when they're trying a case. Now, it's broader than that. I spend a lot of my time in jury selection, helping come up with profiles, helping attorneys decide who they want, and mostly who they don't want, because you have a finite number of people who show up and then you strike jurors, so it's really jury deselection. But essentially, a jury consultant helps the attorney with their case, and we often do focus groups and mock trials and helping them prepare so they can get their message to the jury, they can get the right jury, and then at trial they can make the right arguments and they can craft their presentation so it resonates with those who are making decisions about their client.
Let me ask you a question, because in my practice, I have used mock juries. But one of the things that I always wonder about is, isn't every jury different? And so when you do one of those mock juries for one group, in particular, here at LawNewz, we've been following some cases that are going to be retried. Can you gain any insight from what you learn from one jury that can help with the next?
Sure, and that's what clients and prospective clients always ask me. So, of course, it's a science, and you can't say that, okay, here's how one jury deliberation unfolded, here are the decisions, so that's exactly how it's going to go. No, you're looking for more about rationale that you see in mock trials and focus groups. You want to know how jurors make decisions, what they like and dislike, as opposed to the actual result. However, if you do a mock jury exercise with enough people, say that you have 2 or 3 juries, which is, it's typical to do 3 juries of 10 to 12 in each jury, so say you have 36 people, then you get a good sense of consistency. So if 3 juries come back a certain way and the presentations are going to be similar to what happens at trial, then you can have confidence generalizing. But you touched on something important. One of my most important roles as a jury consultant is to make sure that the methods in place are going to enable us to have confidence in the results of the mock jury exercise for the trial. But that's a big part of what we do to make sure that we don't walk away with a sense of how the trial is going to unfold and then get completely blindsided by it.
Now, you have a psychology background and a lawyer background. Which of those do you rely upon more when you're doing the jury consulting?
I rely more upon my psychology background, my jury psychology background, essentially. Now, the law is certainly important. Lawyers are the ones that are going to do the motions and that are going to do their cross-examinations, but for me it's more the psychology involved. It's about group decision-making, it's about group dynamics, and it's about crafting the message and the presentation in a way that those who are going to render the decision, the jury, are going to embrace. So it's a little more about the psychology involved, and that works out well because the lawyers don't have the psych background, so they need someone with psychology background and some communications ability to help them communicate with the jury.
Tell me a little bit, this afternoon, we're starting a death penalty case, and we've been talking about the death penalty this morning with regard to Marcellus Williams as well as the Valerio case, which starts today. When you're talking to lawyers about death penalty cases, what's the psychology involved to be able to say, yes, I find this person guilty, and yes, I'm willing to put them to death?
Right. It's just a whole new line of questioning. So part of what I do is I not just give them a profile of someone I like or don't like, but it really comes down to the questioning. When lawyers get to ask jurors questions, it's the only time they get information on the jury until after the case when they're talking to them when a verdict has been rendered. So I just tell them and remind them, or in some cases, of the importance of letting the jurors talk, getting them comfortable. There's oftentimes bias, and especially in a death penalty case that jurors harbor, they have this bias, and the trick is to get them to reveal it, because a lot of times if you think about it, you have experience, I have experience, people in this area do, but most jurors come in, they don't know anything about the law, maybe they've seen a few shows, And so it's a little overwhelming. They're in front of other people. They have to uh, give information about themselves, about their opinions, about some of their experiences. So half the battle is just getting the jury comfortable with the setup, with the environment, with the attorneys, and getting them willing to communicate information about themselves and their background so that we have information that we can make intelligent use of in order to decide, do we want to strike them or not. And with the death penalty, everything is just, the stakes are higher, obviously, because this is a person's life. In all other scenarios, in a civil context, it's about money damages, or in a criminal case, it's certainly important. Civil cases are important too. But in a criminal case, is somebody going to be incarcerated? Are you going to find them guilty? But this is sort of at the top of the food chain with that question, because they're going to decide somebody's fate. Did they decide whether or not this person lives or not? So that has to be taken in mind when we talk about how to question prospective jurors in a death penalty case.
And does it then come down to the specific way that you word the questions, that to try to draw the jurors out and ask open-ended questions?
It does, yeah. So a lot of times attorneys have a tendency to ask closed-ended questions. That's right. Because during a cross-examination or during direct examination, during cross, they ask closed-ended questions. They have control of the situation, and attorneys just are typically of that mindset where they don't want to leave anything to chance, and so that's how they're trained. But for jury selection, it's the exact opposite. You pretty much throw that rule book out the window. You want the attorneys to make as if they're almost at a cocktail party or just meeting people on the street, talking to them, getting a dialogue, getting the jurors comfortable. And really, I tell attorneys when I'm suggesting how they should conduct voir dire, I say you should be talking for 20 to 25% of the time, and the juror should be talking 75 to 80% of the time. It's really about information gathering. You're not arguing to them too much at this stage, so let them talk. And yes, the way we phrase questions is very important. And like you said at the end, they're open-ended is the way to do it, so that they don't feel like the attorneys are putting words in their mouths or they're making suggestions. You don't want the jurors to answer questions in the way that they think the lawyers just want them to answer it. So you have to get them comfortable, ask open-ended questions, and create a dialogue so you can hear the language they use for you to determine, oh, you know what they said about the death penalty makes me think they're not going to give this fair shake at it, or what they say, they really seem like they're gung-ho about the death penalty, and then everything in between. So you really want to let them talk, think about the language they use, and then consider that when you decide if they're going to be good or bad for you, depending on if you're the prosecution or the defense. I
have to imagine that one of the hardest things in your job then is to get lawyers to talk only 20% of the time, given that they're used to talking almost 100% of the time.
It is hard. It is hard to get them to relinquish this control, because they like holding court.
Right.
And being the center of the activity, and so it is hard to get them to do that. But the really good ones understand that. They get the value of ceding control to the jury and letting them do the talking, so that they can learn, okay, so yes, they basically have a choice. I can do the talking and then I won't learn much about the jury, or I can relinquish some control of it, let them talk, and then I'll have a better sense of who I need to strike so that I can get fair jurors. In this case, that'll give my client a fair shake.
Now, do you also help lawyers, like in this Valerio case, we know that the events at issue happened in the 80s, and so the evidence is going to be stale, no one can help that. The testimony may be read. Do you help the lawyers throughout the course of the case to make that old, stale evidence as compelling as possible to the psychology of the chosen jurors?
It's going to be hard, but I know that given the circumstances with the stabbings, the prosecution is going to try to use some of the photographs and some of the physical evidence, I think, to really jolt the jury. Now, they don't want to overdo it, because yes, she clearly died, and sometimes when photographs and physical evidence becomes on display too much, then it can backfire, because the jurors get it. They know that yes, this person, he killed her, and it can backfire. They can say, why are you trying to tug at my heartstrings or trying to make me make an emotional decision? Right. But yes, it's up to the prosecution. They have the burden here to make this case come to life, and they're going to have to somehow, because the jurors are going to wonder. They're going to say, okay, so we're here. Let's see, that was over 30 years ago when this happened, so why are we making a decision? They're going to wonder what's been happening for the last 31 years or so. And so that's going to be hard. It's going to be hard for the prosecution to do that, and they're also going to have to keep in mind that there's this gap, and the jurors are going to be wondering exactly why they're here.
Right. Another question, T-Bird, one of our viewers, sent in a question for you, and she wanted to know whether you prefer jury questionnaires, individual questioning, or questioning them as a group. You know, sometimes you take each juror back and set into a separate room. Other times you ask the whole group and they raise their hands. Which do you prefer? What are the benefits, I guess, of each way of doing it?
Generally speaking, so if it's say a sexual assault case or something where there's very sensitive information and people are reluctant to reveal maybe that they were the victim of a sexual assault or they were accused of it or they know somebody, then I think it's better to start off with a jury questionnaire so that people are comfortable revealing some traumatic experience, and then you can follow up with the judge in private. It's not only hard to get somebody to say that in front of everybody else, but it's just not something that should happen. People shouldn't have to come to a big room of people, big room of strangers, have the judge there, have the attorneys, and have to start talking about some very personal experiences that could be embarrassing to somebody. So in that case, I like the jury questionnaire. But overall, I like the questioning the jury as an entire panel, because then you get a little peek in what deliberations are going to look like. So when you question everybody at once, you say, okay, who are the leaders here? Who's comfortable revealing information about themselves and who's not? Who's going to be a follower? Who's going to be a leader? And then you can kind of play off it and say, okay, so juror 1 said that he's going to have a tough time. He's wondering why we're still here, that the defendant served time for 30 years. Shouldn't this be enough? Well, what do you think of that, juror 12? And then juror 12 responds. And then somebody else will say something to the effect of, well, yeah, maybe the defendant here is wasting resources, and I think we should probably consider ending his life if that's what it warrants. So you kind of get a little dialogue going on. And I just gave these examples for this case because those are the factors that they're going to be looked at for why there's such a gap here. But right. I like trying to foster some discussion with everybody in the courtroom, with all the jurors. And I see the main benefit of going one at a time in private if it's something sensitive in nature. But overall, I think it's great to have all the jurors there. Everybody sees the process. They get to know the attorneys get to know them, and you get a sense of how you get a better sense of how a certain juror is going to be in deliberations.
You know, it's fascinating that you say that, because when I choose a jury, we often will ask people to raise their hand but tell them not to give any additional information, because we lawyers, again, are trying to control the process and make sure that they're not influencing each other. But I think it's interesting, to your point, that if they are influencing each other, you want to know who's influencing and who's being influenced, so you can sort of determine the makeup of your jury. Is that fair?
That's completely fair. I would say that you really want them to, when you ask a certain question and the show of hands go up, I would immediately follow up and say, why do you say that? Because then they'll give you their rationale. And you know what, if you say something, if you ask somebody a question and 10 people raise their hands and say yes, they might say yes for completely different reasons. So you do want to delve into what's driving their decision. So yeah, I think it's very important. And to your point about, I know that I hear this from attorneys all the time also, that they're afraid that one juror is going to, quote unquote, poison the panel. They're going to say something and all the other jurors are going to cringe back. So in my experience, you certainly want to know that then. You want to know what somebody's strong bias is, but other jurors aren't going to be influenced by that. If you think about it and you think of the dynamic of play, if somebody has a certain belief about the death penalty, for instance, and then one juror raises their hand and says, you know, I firmly believe that if somebody doesn't pay a parking ticket, that we should assess the death penalty or something like that. Right. You know, it doesn't even have to be an outrageous example. I'll just say if somebody has a strong opinion about how we should be using more of the death penalty, say, somebody might have that belief, we're getting away from it, it just hasn't been used as much. And I really think that if somebody does something like this defendant might have done, then we should elect to put him to death. Well, it's not going to persuade others that, wow, maybe he's right, we should put this person to death. They'll just think, oh, this is somebody who sees it a certain way. It's not going to affect my opinion. In fact, I think the opposite. And if somebody says something really outrageous, it might have the opposite effect. They'll think to themselves, do I really think the same way as this person thinks? So I don't think it's ever an issue for one juror to raise their hand in voir dire and to say something. Now, if they say something that's not in evidence, if they followed the case, that's one thing, but that rarely happens. So I'm never concerned about one juror saying something that's going to make other jurors change their minds or that's going to, quote unquote, poison the panel.
When you have a case like this one, and you've mentioned this a little bit, when there's this much of a delay, do you encourage, between the crime itself and now this trial, do you encourage the lawyers that you're working with to give as many details as possible during jury selection, almost as if, as far as the judge will allow it, to give sort of a mini opening?
I think it's good to, and again with the percentages, I think that probably 80-20 again. 80% of voir dire, maybe 85% is about information gathering, but there's that component that's about 15%, maybe 20, where it's argumentation, where you're starting to get your themes out there, where you're starting to give jurors a roadmap of where you're going to go. But in terms of the jury selection process, yes, I think the more information, to a certain extent, the better, because then the jurors are going to think, okay, they're hearing more information. Oh, that resonates with me. Or the attorneys are going to say, during voir dire, well, this is what you're going to hear, and you're going to hear some witnesses that are going to testify. And when the defendant was in prison, they're going to talk about that. Then it just might jar something in a prospective juror that wouldn't have otherwise. So the more information that is given in voir dire, the more jurors are going to understand what their task is and what they're going to be dealing with, which I think makes it more likely for them to say, oh, you know what? I just cannot see assessing the death penalty. I see all this information that comes out nowadays with DNA evidence that exonerates people, and I've just seen that there are all these people that are now deemed innocent after serving. I cannot do the death penalty, and so sometimes it takes more of an in-depth conversation, right, and additional information to get out to prompt a juror to say, oh yeah, that's right. Now I'm gonna share this with the attorney asking me the question.
Well, Alan, I want to thank you so much for being here with us this morning. It's such a different perspective on what we do here every day, to sort of see what goes into the thought process of choosing a jury and following a jury. I hope you'll come back with us as we continue to discuss and watch these cases. And thank you for being with us here this morning.
Thanks for having me, Heather. Nice to be here.